You're good to go.
Okay. And we're waiting for a Brent Boozy or Boys?
It's Bicey.
Bicey, okay.
Knows he's on, but I don't see his picture. Brent, are you there?
Okay, I think he's on now. All right, Tony, you're excused for the day, so we just have a TRO right now, and we're going to go ahead and get started on Zubarek versus Gonzalez. What do we
Your
have?
Honor, I just gave Brent a call, and he said he's trying to connect. So I don't know. Picture shows, but I don't know that he's actually there.
Okay.
If you just give him a moment, I'd appreciate it.
Sure.
Okay, thank you, Judge, and I will see you in the morning.
Okay. Bye-bye.
Bye.
Is Mr. Boyes, or is he
It's
on the
Bicey.
Bicey? Is he on now?
Let's see him. Hang on, let me call him again. He said he was having trouble getting on for some reason. I'm not sure why.
Okay.
Call him again.
Judge, while we're waiting for Mr. Bicey, plaintiff filed a supplement that was filed at 9:59 a.m. this morning. I don't know if you've had a chance to see that yet.
Let me see. Supplement. Yeah, I see it. Let me go ahead and read it. I had not seen it.
Thank you, Judge.
He'll be here in a minute, Your Honor. He's reporting he's getting the spinning pinwheel at the moment, and it won't connect. So I told him to try it again.
I also got the spinning pinwheel. It must be the day for that.
Okay. Okay. All right. Is he on now?
Brent, are you there? Call again, see what's going on here. Hang on.
Is it Mr. Smelser? He just went away.
Your Honor, that's one of my clients who wanted to be in the hearing.
Okay. Well, guys, why don't we go ahead and get started, and then we can, if this gentleman wants to join us.
Well, the problem is he's the one that's arguing the opposition. I just talked to him, and he can't get the link to work. I told him to go to Zoom USA and put the number in and see if he could get in that way, as opposed to trying to hit the link.
Do the rest of you guys, do the link work?
Yes, sir.
Yeah.
I don't know. I logged in different ways.
Could you call him on his cell phone, Keith, and see if he could
I
just?
called him. I've called him. That's how I know all this. I've called him on his cell phone, and he's like beside himself because he can't get on.
No, he would just be able to talk to the court via your cell if you put him on speakerphone.
Probably not ideal, but let me call him and see what he's getting on the other way. All right, he has now abandoned his computer and is trying to log in through his phone. So we'll see if that works.
I see him right now. Let's see if he comes on. There he is.
Brent, you there? You say you saw him there, Your Honor?
Yeah, he's here.
Oh, there he is. Oh, there he is.
Yes, Judge. Sorry, my apologies. I'm not sure why my Zoom on my computer is not launching, and it tells me I'm in a meeting. So I do apologize for this delay.
Okay. Let's get started.
Thank you, Judge. David Welch on behalf of Mr. Zubarik. I've got Mr. Miller and Mr. Zubarik are also on the line. We filed this TRO as it relates to a special meeting that was held last week on amending the declarations. The declarations can only be amended by express written consent, Judge. That provision is found on page 35 of the TRO within the declarations. To pass the vote, the defendants had to use proxy votes. A copy of the proxy is found on page 49 of the TRO, Judge, and that's just a general, broad, you vote for me proxy. That is not express written consent under the rules. The numbers of the voting has jumped a couple of times. They need 58 votes to pass. Last we heard it was 66-4 with 15 proxies. So our contention is, Judge, the proxies are not adequate to count for a 4 vote, and this should not be amended and has not been amended under the rules. And we need to stop it. If they have filed it, we need to void what they filed, and they need to hold a proper vote. And that's the means of it, Judge.
So I'll make sure I understand your position. So you say they need 66 votes to pass this, but they're not allowed to use proxies. Is that essentially your position?
58, but yes, sir.
So 58 votes to pass, but part of those that they needed, they got that many, they got 66 votes, but 15 of those were proxies, and proxies don't count, so they're not at 66. That's your position?
True.
Response?
Thank you, Judge. In response, we've got 2 main issues with this application before the court. First is that TRO is procedurally defective, Judge. The amendment here has already been recorded with Dallas County property records. So what they are asking for is to basically have a restraining order against something that has already occurred. And there's already an adequate remedy at law for this particular issue. What the plaintiff has put forward here is essentially a challenge to the vote. It's not that there is some sort of irreparable harm or imminent harm that the plaintiff is to experience. Like I just said, this has already been recorded, and the plaintiff has not been harmed here. There's been no facts pled to whatever harm he believes there could be. The adequate remedy, again, is a challenge to the vote. Mr. Zubarik already...
How would the challenge to the vote occur?
The challenge to the vote, Judge, is a certified letter that is written to the HOA. At that point in time, a calculation of the expense for the recount and audit is tabulated and then sent to the person who makes the challenge. The person who makes the challenge then has a period of time to tender the payment for the recount, and then the recount does occur. So that is the proper method, and that is prescribed by the Texas Property Code. It's not by the CC&Rs. CC&Rs, in fact, defer to the Property Code. This is the method set by the state. Substantively, Judge, this is also defective because this amendment is proper. Opposing counsel says that there is a prohibition on proxy votes, but there's no provision whatsoever in the CC&Rs or the bylaws for this HOA that prohibit proxy voting. In fact, to the opposite. In the bylaws, it prescribes the method by which a proxy vote is to be used. It defines what the designated proxy vote is. So there's no position here based in law or in fact as to why there should be an application for a TRO. So for that reason, Judge, we believe that this TRO should be denied. We're also making a request for sanctions for having to come forward to the court with this issue. We've made very clear to opposing counsel and plaintiff that this issue is not something that should be brought before the court because of the ability to have a recount. That is a adequate method by which plaintiff can address this concern. And second, Judge, we also
if they're right though about the proxy voting not being allowed, would a recount make a difference?
Yes, Judge, it would make a difference because that is the position of the recount. The recount is a part of the challenge mechanism. But even still,
can you share the section of the property code that talks about recounts that you're relying on so I can take a look at it?
Yes, Judge. It's property code section 209.0057.
Can someone share that on the screen so I can read it? Is someone sharing it?
I'm not able to share this from my telephone.
If you just give me a minute.
Thank you, Casey.
All right, keep going down. Keep going down. Okay. All right. Response, Mr. Welch?
Thank you, Judge. We're not asking for a recount, and the court's directly on point. A recount's not going to solve this problem. We don't challenge the number of votes. We challenge what qualifies as an active and proper vote, which a recount's not going to tell me. It's just going to tell me how many proxies, how many for, how many against. I'm saying you count, you take their count. I don't want a recount. They're at 66 for, 15 of them are proxies. Proxies are not allowed because they're not express written consent to modify the declaration, as on page 35, and they didn't pass the vote under the law. Council wants to obfuscate what's going on here because they cite to the bylaws, and they say, well, proxies are allowed in the bylaws. That's a totally different document. If I may share my screen, Judge, I just want to show you one thing.
Okay.
This is what we're looking at. This is the declaration, and it stands alone by itself. It's Exhibit 1 to my document. We go to page 35, General Provisions. Notwithstanding Section 1 of this article, so this duration thing about it'll expire within a certain amount of time, may be amended or changed upon the express written consent of at least 2/3 voters. This is the only way to amend this document. It doesn't incorporate the bylaws. It doesn't incorporate proxies or anything. So with that said, Judge.
So what is express written consent? How's that defined?
It's not defined, Judge, and here's the argument of why that's not express written consent. They did these proxies, and the proxies abroad, Mr. Welch, you're going to vote for me on whatever it is. But they also released these absentee ballots, which are, here's what's up for vote. Vote yes or no. That's express written consent, Judge. You know what you're voting for, and you're saying yes or no. The proxies just, you go out there and have a ball with my vote, Judge, and that's not allowed in my opinion.
Is there any case law that defines whether or not a proxy is express written consent or not, or whether these can be counted?
Not that I could find to that specificity, Judge.
Judge, I have something very important to point out about the CC&Rs that we just looked at.
Okay.
And I would ask if opposing counsel could share those again on the screen and take us to page 5 of the CC&Rs.
Where you want me to go?
To page 5 of the CC&Rs. It'll be, looks like document page 15.
Okay.
Is this the right page?
Yes, Judge. At the very top, it says very clearly that the voting requirements, the quorum and notice, are all pertaining to either the articles of incorporation and or the bylaws of the association. So the bylaws here, Judge, they control as to the voting matters. The bylaws further state they define what a proxy is, and they define that as the method by which a member can vote. A proxy is made with express written consent by a member to a designated proxy. The designated proxy then goes in person to the meeting and fills out a proxy ballot for that individual, checking their desired votes. That is what is counted. The desired vote in this case, Judge, was that over 2/3 of membership voted in favor of this amendment. What counsel is trying to argue here is she's trying to split a hair between what he believes should be an express written vote and what the specific bylaws and the CC&Rs provide for. Moreover, Judge, the plaintiff himself has used proxy votes in the past numerous times without any issue. There's been no issues in the history that I have been able to research with this particular organization of issues with property voting. I have 2 declarations, Judge, both of which state that Mr. Zubarak has used proxy votes in the past. Mr. Zubarak is well aware proxy voting is permitted and it satisfies the requirements. In those previous votes, they were amendments to CC&Rs and bylaws, budgetary issues, and voting for the board elections, Judge. So there's, again, no basis in law. There's no basis in fact. This is brought purely for the purposes of harassment and bad faith.
Judge, he's wrong. Number one, let me show you, one, the bylaws don't matter, but he's not using the bylaws correctly. This is the section that says what a proxy is allowed to be in the bylaws. Directed proxy that instructs the holder of the proxy on the specific votes to cast, right? Right here. And then I'm going to jump to the next page, but I don't want to stop you from reading, Judge.
Yeah. Go ahead.
This is the proxy they're talking about. Just cast my vote. Not vote for or against or do anything, just cast my vote. This doesn't even qualify as a proxy under the bylaws, much less an express written consent, which is the only way to amend.
Mr. Welch, where did that proxy come from? Was that attached to the bylaws or was that just something that you found?
This was mailed out to the voters prior to the meeting. It looks like, let me see here, it came out on March 4. They were emailed to the homeowners for the meeting, which was held last Tuesday. I think that was March 23. So that's, I don't know where it came from, Judge, but that's something the HOA created for voting.
All right, response?
Your Honor, if I may.
The
Judge,
ahead,
this, one right, one ranger.
Sure, I'm perfectly capable of responding to this, Judge. The form of the directed proxies is to be determined by the HOA. So what counsel is arguing here is a bit of a pole vault for what section 0.211 is trying to express here. The proxy says specifically that they are delegating their rights to a designated individual to make the vote. So although the directed proxy that we have here, it does say to vote in favor of that particular owner. And then again, it would be on page 4 of the bylaws, the form of directed proxies is to be prepared by the association, and that is the form that is to be used. So I'm unsure as to how counsel is trying to argue
on
that
you're cutting out, so I can't hear everything you're saying, but are you saying that this proxy says that they are to vote in favor of this resolution? Is that what it says, or what does the proxy say?
It gives the holder of the proxy the right to cast the vote on behalf of the member. Then that proxy voter then goes to the meeting and then marks on a proxy owner ballot the specific vote for that proxy member, or for the member who's delegated their proxy. And again, in the bylaws,
So
section,
what I'm trying to get at is it doesn't discuss this particular matter. It just says you can vote on anything you want to at that particular meeting, right?
True.
Yes, so it does say, it specifically states approval of amendments to the declarations or other dedicatory instruments of the association.
Okay, where does it say that? Okay, let's
Says
see.
that towards the bottom of the first full paragraph under the 2 options.
Okay, I see that. All right, that's okay. I'm going to go ahead and deny the TRO. Do you have a proposed order that you've submitted?
Yes, Judge.
Okay, you have?
Yes, we submitted a TRO earlier this afternoon. Judge, we would also like to have a ruling on our motion for sanctions for bringing this issue before the court, being that there is a remedy at law and being that the plaintiff himself has used proxy votes in this exact same way in the past. We notified counsel of this last week during the vote. Again, over the weekend, we made this very clear that we did not want to have to go through this argument. Attorney fees have been expended for the HOA that we believe are unnecessary. And this has been brought again for the purposes of, in bad faith, to cause further delay and expense in an attempt to basically undermine the democratic will of the HOA.
Response to the sanctions.
Not been set for hearing, Judge. You have to have an evidentiary hearing on Rule 13 sanctions. It would be improper for you to make any kind of ruling on that if you're going to entertain it, and I would object to that. And I plan to push forward with a temporary injunction on this matter.
Okay.
Judge, then we would request a time for the hearing to take place.
What I'm going to do, what I want you guys to do is, if you're really going to go forward with this temporary injunction, then go ahead and set your motion for sanctions at the same time. Does that make sense?
And should we just get in touch with the coordinator, Judge? Clerk?
Yeah. If you want to, you can go ahead and do that.
Understood. Thank you, Judge.
Anything else, guys?
That's all we have, Judge.
Okay, guys. Good to see you. You guys be
Thank
safe.
you for your consideration with the problems with the Zoom. So thanks.
Oh, that stuff happens.
Thank you. I'm sorry.
That's okay. All right. Thanks a lot, guys.
Thank you, Your Honor.
Thank you.
All right. So, did you guys have any questions about that? Oh, let me shoot. 720. When would I have done that, Rhonda? Hey, if I did, I'm looking at it. I didn't write it down. If I did. So, Rhonda, so this is the deal, and I guess Max, maybe if you could stay on the line for this, I guess you guys all can stay if you want to. So next Monday, my wife